And then here is the response from Srem-Sai, Counsel for the Republic. He says, respectfully, my lord, we are opposed to the request on grounds that the subject matter request does not satisfy the grounds for further disclosure. My lord, the Supreme Court recent decision is to all intents and purposes an obiter, and regardless of how elaborate the court puts it down, cannot constitute a ratio decidendi. Okay, good point. I believe she's making this point because Atta Akyea may have argued that based on a Supreme Court decision, these recordings must be given. And the Deputy Attorney General is trying to distinguish, as they say, those Supreme Court decisions, calling them obiter. That's another conversation we can have. Obiter is not the main ruling. It's something that a judge says. The ratio decidendi is the main ruling. Ratio decidendi is Latin. Some say decidendi, which is the germane matter of. So if they take me to court or they take anybody to court and they say that you crossed the red traffic light, and the judge says that, yes, I believe that he crossed the red traffic lights. I don't even like the black car he was using. Black cars are not very good because when you drive black cars in the afternoon, you can't see well. All of that, what the judge said, black cars are not very good. If you drive a black car in the afternoon, you can't see well. It's called obiter. It's not the main issue. The main issue that the judge was ruling was whether the accused person has crossed the red light or not. So Srem-Sai is saying, now what is important that can be imposed on the court is the ratio. Where a Supreme Court has decided something, all other lower courts must follow the decision of the Supreme Court in a similar or the same matter. So sorry, I needed to digress to explain that. But let's get back onto the thing. So he says that the Supreme Court's thing was all not ratio. It continues. It says, my lord, this is the Attorney General speaking. The issues before the court is what determines what the ratio of a decision is. Correct. If the court decides to veer off and make pronouncements on matters which do not form part of the issues before it, and in respect of which arguments were never taken, the authorities on what constitutes judicial precedent is clear on the matter. And therefore, this court and all other courts are not in any way bound to follow a decision which is contrary to precedent. So the Attorney General opposed the point that the recordings from Iyoko should also be brought to the court. He opposed it vehemently. He goes on to say, my lord, the precedent for this matter still stands, which is a Supreme Court well-considered decision in Boahene, which this court has digested in my lord's erudite, most immaculate ruling, which is that relevance is a key consideration in determining application for further disclosure, respectfully submitted. So the Attorney General is saying that the recording at Iyoko is not relevant. And then Atta Akyea said it's relevant. Eventually, the Atta Akyea responded, but we will not take the response because we don't have time. And then the arguments continued. But eventually the court said, by court, the opposition is overruled. The audio recordings in the custody of Iyoko in respect of the interrogation of Edith, Ruby, Opokuwa, Adumwa, if any, be procured by the Attorney General and filed as a further disclosure, same to be filed not later than close of day tomorrow, 13th November 2025. So this is what happened. This is what happened in the court. So you get it, isn't it? Now, the judge said, bring the other statements, bring also the audio requirements. So the Attorney General's opposition was overruled. All right. The cross-examination then continued. Atta Akyea said, I put it to you that the only reason why Iyoko admitted you to bail on pain of incarceration is because you were a suspect. So the lady said that when she went to Iyoko, she was admitted to bail. And Atta Akyea is trying to say that you admitted to bail because you were a suspect. And then let's move on. She says, my lord, I do not know. And the question is, at the last sitting, you were making a comparison of two invoices which had the same invoice number, NSC006, generated by ISC Holdings Limited. Then kindly refresh your memory on this. So she says, yes, my lord, they give her some documents. Then the question is, the items as described in the two, these are the invoices for the purchase of the equipment that has become the center of this trial. The items as described in the two invoices are different. Is that not so? Says, my lord, there are two different items with the same invoice number. I remember I said we had not seen one for procurement of cyber defense systems in our payment records. What we had was the procurement of digitized investigative auditing systems with invoice number so and so in our records. Question is, with one of the invoices, it is addressed to you. It's addressed to who? He says, which one of the invoices addressed to who? He says, my lord, one is addressed to National Security Council, which was not the one we paid for. Then the question is, and the other is addressed to who? says, my Lord, that is addressed to BNC, Accra, Ghana. Okay. Then the question is there also NSC stroke BNC there? Says, my Lord, it is BNC. Then the question is, can you see a customer ID on the invoice number, so, which relates to digitized investigative audit system, exhibit B4? They show it to her. Says, my Lord, the customer ID number is NSC. Okay. What is the customer ID number on the invoice relating to the cybersecurity equipment identified as the document? The answer is, my Lord, the customer ID in relation to the procurement of the cyber defense system is NSC BNC. Question. So how do you come to know the invoices relating to the digitized investigative auditing systems? Then she says, my Lord, the digitized investigative auditing systems, which is also NSC 006, was what we made payment for in our records. Then the question is, who delivers the invoices to you? Says, my Lord, as I mentioned earlier, my boss is the one who sends it to me. Sometimes I am on copy in the email, but I still take instructions from my boss on what exactly to do. His boss is the first accused, Adu Boahene. Question is, when your boss has not sent a copy of the invoice to you and you are not kept in the loop in the email, you have no knowledge of the invoice. Is that not so? And said, yes, my Lord. So the court then rules. Suit is adjourned to the 9th, 10th, and 11th December 2025 for continuation of cross-examination of second prosecution witness by counsel for the accused person. Witness steps down. So this is what happened. This is the latest. The lady is now being cross-examined. It turned out that two of the statements that she wrote, which the defense counsel were hoping to rely on, was not available. An application was made by Atta Akyea. It was successful. That application initially was not opposed by Srem-Sai, the Deputy Attorney General, who is a lawyer on account. Then another application was made by Atta Akyea that we want also the video recording, the video and the audio recording of the interrogation when you went to Yoko. And that was vehemently opposed by the Deputy Attorney General, but the court ruled against him. We do not know whether the Attorney General will be seeking to test this at the Court of Appeal, because he can file an appeal to the Court of Appeal asking the courts to, or maybe he can go with a straight application to the Supreme Court, an application in certiorari, to quash the decision of the High Court, to bring those things. We don't know whether that's what is happening. We are not sure. But right now, we also don't know whether those documents have been delivered. In fact, we have to check tomorrow with the courts whether those things have been delivered. But we don't know. But this is the latest on the Adu Boahene trial. So you can make how you want to see it.